Good evening, everyone. Tonight is another opportunity for us to have Legal Hour program, proudly sponsored by CITI Law Solicitors. If today is the first time that you have joined us, we do this program in English every Tuesday. And obviously, on Thursday, MC Chaka hosts the program and we do it in Twi for the benefit of all the Ghanaians living in the diaspora and those even living abroad. But what is significant is that this program is about you. It's about making life much easier for those of you either living here or living abroad to understand the UK law. It's about making law affordable. It's about giving you opportunity for you to ask that legal question that has been lingering in your mind. It's an opportunity for you to have a cheaper way of getting legal advice. This is why we bring you this program. This program is proudly sponsored by CITI Law Solicitors. And tonight I'll be looking at immigration, specifically sponsorship worker visa applications. So we looked at the health and care worker visa applications and how you can be successful in making those applications, especially for those of you living abroad with the intention, with a goal, ambition of traveling to the UK. And for those of you who are here in the UK, either as students and want to switch, or maybe you have completed your postgraduate program and you want to enroll on this sponsorship worker visa program or scheme, tonight is your opportunity to get this free legal advice as I take you deep into how the sponsorship visa application works and how you can be successful in making those applications, including how you can bring your family, your entire family, your wife or partner and children under the age of 18. So I will look at the overview of the sponsorship visa applications, specifically the healthcare and health and care worker visa applications and how those applicants can be successful in those applications and what they need in making those successful applications and why some of these applications can be refused. So tonight is a perfect opportunity for you who have been waiting for such a program to understand the details of how this sponsorship worker scheme works. And that's why I'm here tonight. As I always say, this program is proudly sponsored by CITI Law Solicitors. And you can watch this program either on Facebook, YouTube, or listen to it from City Media Radio. If you want to watch this program on Facebook, you can either watch it on City Media TV, or you can watch it on my own personal profile, Thomas Berbon. For those of you who are watching from Thomas Berbon profile, I always urge you to gradually migrate to subscribe and follow the City Media TV, because gradually I will not be doing my broadcast on my personal profile because City Media TV has taken over the territory. But on YouTube, you can watch this program on YouTube through CITI Law Solicitors channel. And obviously, as I've said earlier, if you want to listen to the radio because you're at work and you can't watch on your phone, you can obviously listen to it from the radio. So tonight, I'm giving viewers opportunity to invite their friends, to share the links, And join me tonight to get this free legal advice. I'm sure there is a family member somewhere who wants to migrate. It is not just about nurses. It is not just about doctors. It is about you who probably doesn't even have a qualification. And tonight I'm going to reveal the secret in being successful in these applications. On this platform, I made it clear there is a 250,000 shortage in the health sector alone. And these vacancies are still there. CITI Law Solicitors, we represent care workers in making successful applications for sponsorship visas, so that these care workers can bring people from abroad. So we know that these job codes, categories, are in a shortage occupation rate. It is for that reason that Home Office is always granting sponsorship licenses to these organizations to enable them to recruit globally. And that is why I am here tonight, to give you the insight into making your application successful. So please, as I go on short commercial break, it's an opportunity for you to invite your friends, to share the links, and obviously, after this commercial break, I will take my time to gradually take viewers into the details of how to be successful in your health and care worker visa application, which is the topic for tonight. So please don't go away, and I'll be back in just a minute. Thank you for your patience. Tonight, as I've said earlier, for my intro, I'm taking viewers through the sponsorship visa route applications and how people can be successful in those applications. And I'm looking at, because of when we talk about sponsorship visa applications or skilled visa applications, there are various skills, there are various jobs, there are various categories of visa applications when applications are being made under the sponsorship or skilled worker route. But tonight I'm looking specifically at the health and care worker visa applications. The first thing to note is that before anyone would want to make these applications to come to the UK, or if they are UK and they want to switch from one category to the other, then of course they need to find a sponsor. And I'm sure most of you are wondering, well, of course, lawyer, it's always difficult to find a sponsor. I'm going to show you the secret tonight. But most importantly, I have obviously looked at this in my previous videos in terms of how to make sponsorship license applications for businesses. And of course, we'll be making these applications for a lot of businesses. And I'm happy to say that most of you are obviously enjoying the fruits of these licenses that have been successfully granted to you. But tonight I'm looking at individuals who want to rely on the sponsorship visa route to either come to the UK or to switch from the existing category of visa to another category of visa. That's what I'm looking at tonight. As an overview, in looking at the health and care worker visa applications, most times people have this misconception that this is just about nurses, midwives. It is not. It's about all the jobs in the health and social care sector. And obviously, when you look at the health and social care sector, there are various categories of jobs. In fact, if you look at the job codes under the sponsorship worker scheme, there are numerous job codes. There are senior care workers, there are frontline care workers, there are care managers, there are care directors, there are nurses, doctors, physicians. But tonight, I'm looking at the healthcare or the care worker sector. Now, before one will make this application, as I've always pointed out, you need to have a sponsor. But the point is that there are also requirements to satisfy under this route. And I'm going to take viewers slowly into these requirements and how they can satisfy them. Now, when one has identified a sponsor, then obviously when one is making these applications, then there are some documents, there are some requirements that need to be certified. So you more or less categorize them in points. The license, the certificate of sponsorship gives that person points. Then there is, for those of you who are not nurses and want to come to the UK, then there is a qualification requirement. And I can narrow this down to English language requirement. Because depending on the category of the healthcare sector that you want to work, you may not necessarily need a degree. In fact, you can even become a senior care worker or a manager without necessarily being required to produce degree certificate. So in this case, the common qualification required in most cases is the B1, which is the English framework that you need to satisfy, which is speaking, listening, reading, and writing. These 4 things. So it means that it is so easy when we talk about skilled worker. Most people are of the view that you need to be an engineer, you need to be an IT technician, you need to be a doctor, you need to be a nurse. In fact, it's not. You can simply be somebody, or you can simply be someone who have just completed senior secondary school or have done A-level. But in most cases, you don't even need these qualifications at all, because the immigration will set the requirements. And in most cases, when you are making these applications, even those who have degrees, they need to ensure that their degree certificates are taught in English. And these degree certificates are then translated. So most times when people are asked to produce their degree, they think that that is what earns them the point. It is not. If your degree is taught in English, then of course it means that once it's translated by actors, formerly NARIC, that it means that that obviously gives you equivalence of the B1, which is reading, writing, and obviously understanding and listening. So that gives you that qualification, which is the English requirement. If you are not coming in as a nurse, and you are just coming in as a healthcare worker. But the other point is that it is to satisfy your employer that you are qualified for that job. But the good thing is that this sponsorship licensing scheme is like a franchise between Home Office and that employer. So those employers have numerous powers in terms of recruiting globally. So once they are satisfied that your CV or whatever qualification you have or experience you have satisfy their own requirements, then the only thing that you need to satisfy is a B1, which is quite understandably being able to read, write, listen, and understand. But most importantly, those of you who may not even be able to read, write, understand, it doesn't mean that you are cut off from this scheme, because you might be a dependent, or in this case you might be either a child or a partner. So if, for example, I'm married and I'm uneducated, and my wife is the one who has been to senior secondary school and therefore can speak English and write English, then of course, if my wife is able to write the B1 and pass that exam, it means that I can simply come to the UK with my wife as her dependent or her spouse. So that's the first point. The other point is that if one is below the age of 28 and above 18, and they have lived in any country for up to 12 months, then they have to provide criminal record or criminal record certificate to show that they are free of convictions, because this only applies to only certain areas of the category in terms of the job that you are coming to perform in the UK. So in this case, if, for example, you are going to work with the vulnerable adults, then of course, even in the UK, you have to do what you call either DBS or CRB to satisfy that you are free of all convictions. And in fact, if there are any convictions, they are not so material that it will affect the nature of the job or the category of area of that practice. It means that even if you are coming from abroad, you also need to meet the criminal record requirement. But when you have met that requirement, and I'm taking this gradually because I know that most of you watching have keen interest and you want to understand how this works. Once you have satisfied this requirement, then the next thing is, most people don't know, but there is what they call financial requirement. There is financial requirement that you also need to satisfy. But the advantage here is that this financial requirement can either be satisfied by the sponsor, in this case, your employer, or it can be satisfied by you as the applicant. And obviously, if you are coming with dependents, such as wife or husband and children, then there is financial requirement also to satisfy. And in this case, these financial requirements are, for those of you who have lived in the UK for more than 12 months, you don't need to certify any financial requirement whatsoever, because you are already in the UK, and it's assumed that you probably would have been able to pay for your accommodation, and you have a suitable accommodation, and therefore you don't need to certify that financial requirement. But for those of you coming from abroad, you will need, obviously, to satisfy this financial requirement. It's only about 1,270. The reason being that when you come to the UK, you're obviously coming to work, and therefore you will probably need to have somewhere to live. You will pay rent, and you need to feed. You need to take transportation to the workplace. And therefore, this minimum financial requirement is to enable you to be able to afford these facilities before you get your first paycheck. Because obviously, the skilled worker, it's only for those who are coming to the UK to work. And you are guaranteed of job even before you come to the UK, or you switch from your student visa to another category. But having said that, it means that this 1,270 is a minimum amount that you need to satisfy. And of course, this is an amount that should have held in your own account for the specified period, and needs to do the application within a specified period. And when I make reference to specified period, I'm looking at mandatory periods such as 28 days or more, and within 31 days of you making that application. But if, for example, you are coming with a partner, then in this case, there is additional financial requirement, again, quite low. Your partner, if you guys are coming together, means that you need to satisfy additional £285. And then if you are coming with a child, then that child needs to also satisfy minimum requirement of 315, so you have your £600 plus a 270, 1,270. And each additional child, there is also £200. And I'm giving these figures from memory, but those are the requirements, financial requirements, that you need to satisfy in order to be successful in that application. So within this short period, I have made mention of three things, three important things as a skilled worker visa applicant, that you need to have your English language requirement. If you are becoming a nurse, then of course there are other requirements that you want to satisfy. But I want people to understand that people are not just coming here only when they have degrees. People are coming here even when they don't have degrees. And they are still categorized as skilled workers. So don't be confused that you only need degree in order for you to come to the UK as a skilled worker. Because that's not the case. It is not defined anywhere in the requirements. However, you need to certify the English language PUI, which is in the European framework. And obviously, the third point is the criminal record requirement, which is so important that you also need to satisfy. In most cases, you can simply get these documents from the police station, or if you are in Ghana, from the headquarters. But having said this, it means that these three requirements have been satisfied. So quite clearly, there is no grounds, there is no mandatory ground for these applications to be refused as long as these three requirements have been satisfied. So it is so easy. It is so easy for people to be successful in these applications. But the danger is that because these are mandatory requirements, and I make reference to specified dates and specified documents, it means that if there is any error, there is any absence of any of these documents, then it's more likely that this application mandatorily will be refused. But tonight I am not going into the general grounds of refusal, because that will be going deep into the immigration rules. But in any event, whenever you are making these applications, there are also general grounds for refusal which apply to every single application that one embarks on, either in the UK or from abroad. But obviously, tonight is not for me to look at the general grounds of refusal because it's quite broad. However, it is material to this application that I have just explained to you tonight. Going further, the tangible question or the famous question most people will be asking is, for example, how can people living here also switch from whatever visa that they have currently to a skilled worker visa? Because remember, apart from the frontline care workers visa route, which entitles applicants to a year visa, which can then be extended whilst you're in the UK to other categories. Most of these visas are issued up to about 3 years or maximum of 5 years. And those who have these 5 years, it leads to what they call indefinite leave to remain. And eventually, these people, having attained the indefinite leave to remain, can then naturalize, subject to meeting the requirements therein, to become British citizens. So this is a route that allows people, instead of some people being on the 10-year route to indefinite leave to remain, people can be on it, and within 5 years they can also be successful in getting indefinite leave to remain. The next point that I want to look at is the cost involved. The cost involved. Now, normally, if the application is for up to 3 years, I think it's about 270. And for those of you who want to make application for the 5 years, which eventually leads to the indefinite leave to remain, it's around 479. Now, if you compare this application fee to that of those who are even applying for indefinite leave to remain, and I made one of those applications just before I came to this studio, it's over £2,000. And for those of you who are on this 10-year route, obviously, each time you are making these applications, you are paying about £2,613 approximately, with NHS surcharge or immigration health surcharge inclusive. So the cost comparatively is far cheaper. The route to indefinite leave to remain is quite shorter. However, most of you will be itching to know which people are entitled to switch. Now over here, I am only specifying the rules. In some instances, probably you may need some legal assistance, but the rules makes it clear that there are only few categories of people in the UK or who are in certain categories of visa who cannot switch. I am surprised that I have not even found those who are living here illegally as not being in the category who cannot switch, but obviously I'm sure that is quite apparent. However, the people that cannot normally switch are those who are here as on domestic care worker visa. That means you are working for someone privately as a domestic assistant. For example, if I was living in Ghana and I was coming to the UK as a rich man, then of course I can come with my domestic worker. My domestic worker will work for me in my house, either being a nanny and doing the house chores. But that particular domestic worker is not eligible to switch to sponsorship skilled worker route. That's the first category of visas that are not entitled to switch. The second category of those who are not entitled to switch are those on visit visa. And I get these questions a lot in practice. If you are on a visit visa, you are not allowed to switch in country from that visit visa to sponsorship or skilled worker visa. It means that you may have to go back to wherever you came from and apply to come back in. The third category of people who cannot switch are those on immigration bail. So you realize that, and I think there are two more that are not entitled to switch. So you realize that probably, and this is going to be test. I'm sure there are going to be cases that are going to be tested because the Secretary of State have laid out those who cannot switch. My question to you tonight is that, does that mean that if, for example, you made an EUSS application and that application was not successful and you have a pending appeal, are you entitled to switch? My answer to you, based on the law, is yes. But the Home Office, as we know, may sometimes refuse this application, but it might be unlawful. The reason being that the Secretary of State have only specified those who cannot switch. So he has given a floodgate of categories of people who automatically can switch. Because if I come to your house and you tell me that, Thomas, you cannot eat any food in these three pots, green, yellow, red, that's my Ghana flag. It means that any pot, any food in either green pot, yellow pot, or red pot, I cannot eat any food from that pot. It means that from your instruction, any other pot filled with any food with any different color allows me to eat it. I am in fact entitled to eat it. So in this case, I'm looking at people who are able to switch. And in this case, if the Secretary of State have laid out those who can switch, those who cannot switch, it means that any other person, those of you who do logical reason, who does not fall within that category, they are entitled to switch. But I'm sure that eventually, because this was only introduced about a year ago, and in fact, a lot of applications are being successful. And we are going to test most of these cases when there are refusals. But I'm telling you tonight, if you are outside any of these categories, and I know most of you are working in a care sector, some of you have got your e-settlement scheme applications refused, you've made an appeal, the appeal is pending, your employer is already working, you are already working for your employer, and in fact, quite rightly so, you are entitled to work under the paragraph 3C of the Immigration Act 1971, which means that if your application is refused and you made an appeal which is then pending, then you are entitled to work. So you probably have to be considering whether or not, if you are unsuccessful in your EUSS application and working in the care sector, maybe you may have to have a discussion with your employer whether she can migrate you onto the skilled worker scheme. Please share this video. I know it's going to help people. Having said this, I have now looked at the costs, I have looked at the requirements, but I am gradually coming to the point where when people have been successful in these applications, they also have requirements that they need to satisfy. And at this point, I have spoken for some time, and I want to take the opportunity to acknowledge those who are watching tonight. I want people to take this opportunity because there is a shortage in the healthcare sector. Now, tonight I have Louis Entry, I have Fred Asare, who is watching. Thank you tonight, Louis. It's so nice to have you on board. I have Ernestina Kakari, what should I say? Ernestina Kakari is always here. Thank you so much for always coming to support the program. I have Eniola Balugan. It's a great insight. Thank you, Eniola. I have Tiga Opa. It's a great watching all the way from I think Nigeria. I have Fortune, a message. Fortune, thank you so much for joining us. I have Ernestina. It's a great job. Yes, I thank all of you for coming on board. Eventually or gradually, I am coming because I don't want to spend too much time here. I have gone so much into this. I'm gradually going to talk about two more things, and then if viewers have questions, this is an opportunity for people to have free legal advice. So the point here is that when people have gone through all these procedures and eventually have been successful in getting this sponsorship worker visa or skilled worker visa to the UK, what are they entitled to do? One, they are entitled to work with that employer, but they don't become slaves because they are also entitled to switch. So for example, if you came in as a frontline care worker and you worked for about a year, you gain experience, and you got another job within the same organization, you can switch from that 1 year to a 5-year route, which leads to an indefinite leave to remain. Or if you get another job with another employer with a different job code, for example, you came in as frontline care worker, you gain experience, you then become a senior care worker or a manager, a care manager, and you got that opportunity to work for another organization, you can also switch and make further applications and work with that new employer. What people must not lose sight of is that whenever you want to go and work for a new employer, you are entitled to work for another employer, or to do additional job. And again, I am giving this insight. You are entitled to do additional 20 hours with another employer who is not your sponsor. But if you go beyond that 20 hours, then probably that employer, if it's a different job role that you are performing there, you could also apply to have a visa in that category. Because you can only do 20 hours in addition to whatever job that you are performing with your existing employer. So people should take sight, or should take note of that, so that it will not be in breach of working against their visa conditions, which could eventually affect their indefinite leave to remain applications. So there are two fundamental words that I've used here. Normally I am very careful with my choice of words. It means that from what I've explained, there are those who can switch from one category. We normally have a job code, so you can switch from one category to another job if the job codes are different, or from one organization to another organization if the employers and sponsors are different in nature in terms of what you do. But you are also entitled to upgrade or to update. In this case, the right word to use is to update your visa. So let's say you came in as a senior care worker, and now you have become a director or you have become a manager. Then you can update your visa to a different category. So people should take note. I know this is quite detailed to those who are not familiar with these rules or visa rules. So these are some of the things that people should be mindful of. But to summarize my show tonight, it is not only those who have degree who are entitled to come to the UK to work, especially in the health and care sector. People who are, even with respect to them, illiterates, they can come in as dependents, spouses, children. Those who don't have degree, as long as they meet this English language requirement B1, they are also entitled to make this application, provided they have found an approved sponsor. An approved sponsor is an employer who is listed on the Home Office sponsorship license list. But obviously, people need to meet the criminal record requirement, they need to meet the sponsorship requirement, they also need to meet the financial requirement, which in this case can be taken care of by the sponsor, in this case the employer, who will then make note on the SMS. So, quite clearly, it is so easy for people to meet these application requirements. And obviously, it's a route that is currently running. And as I've said, that in practice, city law solicitors, we've made application for employers who have been successful, who are recruiting currently. And most of these employers are struggling to get people to come and work for them. But I'm not here to advertise for them because I'm a solicitor of England and Wales. I'm not a recruiter. But however, I want to assure you that these employers are looking for staff, because this is a shortage area that the UK requires people to come and work. So tonight it's been privilege having all of you here. I'm going to obviously advertise the business of our sponsor, and our sponsor for this program is CITI Law Solicitors. For those of you who don't know CITI Law Solicitors, CITI Law Solicitors is a solicitors firm with qualified solicitors based in Barking, very close to the Barking station. And they specialize in numerous areas of law: immigration, employment, family, personal injury and criminal negligence, consumer law, commercial law, and dispute resolution. So we specialize in numerous areas of law, and I'm going to take the opportunity to just explain some of the things that CITI Law Solicitors specialize in and how CITI Law Solicitors can help you in unraveling that mystery that has become a burden. The professionals are here to help you. We are here because of you. We are here to take your legal matter and win that case for you. So, CITI Law Solicitors is located at Unit 113 Barking Enterprise Center, 50 Cambridge Road, Barking, SS IG 11 8FJ. Our office numbers are 020 33 55 0782. I repeat, 020 33 55 0782. Emergency contact number is 0777 777 210 4967. Please, if you have any matter that is not urgent, you can call the office number, and our solicitors are ready. Sometimes when you call the emergency number, obviously I normally carry the emergency number. I might be in court, my colleagues might equally be in court, but there is always other people in the office who are willing to answer your call and leave message for whichever solicitor that is dealing with your case. So we specialize, as I said, in immigration. Last week I took my time to explain about the Rwanda and UK refugee agreement, and of course I'm sure most of you have taken immense advice from it, and going forward, whenever you want to seek an asylum or to get a refugee, should be recognized as a refugee or have refugee status, you probably need to seek proper legal advice on it. We specialize in employment law. If you are having issues with bullying and harassment, discrimination, racial discrimination, disability discrimination, religious discrimination, we specialize in all these areas. Of course, if you have been unfairly dismissed, we are here to support you with your case with no win, no fee. We only take a token of the case. These cases take long. I have been running some cases for it's almost 2 years now. but the end justify the means. Eventually, if you have a good case and we take it up, eventually you are going to make a gain. So if you have been dismissed unfairly, don't just ignore it. You could be entitled to compensation. Family law. We are family law accredited. We are not just solicitors. We have accreditation in family law. What that means is that we are at the peak of the practice when it comes to family law. Therefore, when you bring your family law case, for example, matrimonial matter, if you are going through divorce and you want us to assist you to maximize your portion of the matrimonial assets, CITI law solicitors is where to come to. If you are being abused at home and you want to make non-molestation order, occupation order, to take that perpetrator out of the house, we are here to support you. If, on the other hand, you are defending a ridiculous claim of non-molestation order and occupation order, and you are being unfairly taken out of that house, and these days I must forewarn you guys, under the Domestic Abuse Act 2020, it is now criminal offense. Personally, CITI law solicitors, we have dealt with the case. I personally dealt with it. That particular individual has been charged and convicted for domestic abuse. In the past, it is just a family law issue. But from 2020, this can be criminal offense, and people can receive custodial sentences. And of course, there are numerous implications, adverse implications for those who end up being charged and successfully being convicted. It means that whenever you are dealing with some of these issues, domestic abuse, non-molestation or occupation order, please seek proper legal advice, because you could end up in prison for domestic abuse. But CITI law solicitors, we are here to make this life easier for you. That is why we are here. Personal injuries and clinical negligence. If you ever had accident, please, it's not every accident that you be entitled to a claim of compensation. If you only had accident that it was not your fault, I have been doing this program on this platform most of the time. You first have to prove that that accident is not your fault, or that particular employer was negligent and they caused the accident by, for example, water being on the floor without securing it, or something fell on the floor, he didn't take care of it, and then he slipped or he tripped on it. It's only those cases that the employer is negligent or has caused it that you could be entitled to a claim. If by your own following or your own error or mistake you got injured, the employer might say that they are not responsible for your injuries. But in all cases, CITI law solicitors is willing to assess the merit of this case, and if you have any merit, we'll do this case on no win, no fee basis. So personal injury, CITI law solicitors is your one stop. Clinical negligence, if you ever went for treatment and you feel that there was error, in fact, some cases people get as much as 200,000, 150, thousands of pounds, because some people might go for eye surgery and they may lose an eye. They are deformed for life. They need to be compensated. Commercial dispute and civil litigation. If you have a business, if you are owed by somebody, if you have a business, most of us run businesses, we don't put contracts, we don't put agreements in place, we do our business anyhow, and not too soon went into trouble. CITI law solicitors is here to support all these micro businesses, to help them to have proper structure in place so that they don't become victims. people are signing agreements without reading them and getting into trouble and being taken to court for thousands of pounds, sometimes 30,000, 20,000, just because you signed something without understanding it. If you had city law solicitors, probably we would have advised you on it. This is why we are here for small businesses. Housing law, if that house is at a disrepair state, damps, molds, broken windows, broken doors, wires, fences broken, city law solicitors is here to claim that compensation for you. Media and entertainment, for those of you who own businesses, you want to register your trademark, you have a trademark that somebody is trying to register, the same class of business, you need to protect your business. We are here to assist you. So city law solicitors, we don't just specialize in immigration, we are specialized in numerous areas of the law. It's a one-stop solicitor center where you can get all your solutions to your legal problems. It's been a privilege to have you on board. I'm so thrilled for all of you who have joined me tonight. I thank you all for coming on board. On Thursday, MC Chaka is going to be here. We're going to have this program in Tree. And I'll again take my time to explain everything in Tree so that all of you can understand and take advantage of this opportunity. Those of you who want to get in touch with MC Chaka, I'm sure on Thursday when he comes, he's going to make numerous announcements. But tonight has been an opportunity for me to explain the law. That is my job. That is what City Law Solicitors brings to you. So I want to thank all of you for joining us tonight. God bless you. God bless you. Good night.